Please enjoy a brief presentation by Valerie Santos from LawPay prior to today's session.
Good morning. My name is Valerie Santos and I'm with LawPay, and most of you are familiar with us, but I just wanted to pop in. Thank you for having us as a sponsor and give you a quick few tips of ways for you to get paid faster. So if you're not already accepting credit card payments, you should be, but if you are accepting them, you should put a button on your website so your clients can go and visit you anytime, even outside of business hours. You should have your client set up on automatic schedule payments so that your team isn't spending admin hours chasing down payments. You should be sending quick bills where your client has all the information at their fingertips with a click and pay. And bonus, we are introducing QR codes coming in 2 weeks. So you can just send a QR code to your client. They can click it from their phone and make a payment. If you want to know more, visit our booth, and we are giving a pair of AirPods away. So stop by, enter to win, and have a great conference. Thanks. Bye.
Thank you, Valerie. Good afternoon and welcome to the 2021 AILA Annual Conference. We're pleased to present the session titled Hot Topics Session with AILA National Officers. I'm Emmy Smith, and it's my pleasure to be your session moderator. I'd like to formally welcome all participants who are joining us today. Thank you also to LawPay for sponsoring this session. LawPay is a proud member benefit of AILA, offering a leading payment technology developed for lawyers with the highest levels of support, security, and AILA compliance. Sign up by June 30th and pay no monthly fee for the rest of the year, plus the first 3 months of 2022 as your AILA member benefit. Please note that today's session is being recorded and it will be available on demand within 24 hours. You may ask questions by typing in to the Q&A box. All conference handouts and materials are available in your AILA Agora digital library. If you'd like to turn off subtitles, press the live transcript button located at the bottom right of your screen and select Hide Subtitle, which will then disable the live transcript. At this time, I'd like to turn the session over to our discussion leader, Benjamin Johnson, AILA's Executive Director.
Thank you, Emmy. And good morning, everyone. Thanks for joining the 2021 Hot Topics panel. I noticed a dog photo right there in the beginning, so that was either a mistake or the smartest advertising from LawPay ever. It was wonderful. So anyway, thank you all for being here. I want to do some quick introductions, sort of the order that you'll be hearing from folks in this panel. I'm going to say a few words about the political landscape, and then I'm going to switch it over to Jennifer Menier, AILA's current president, who will pass the baton to Alan Orr, AILA's president-elect and soon-to-be president. He will then pass it. We're going to do a little bit of change in the actual leadership order to Farshad Oji, who is the second vice president at AILA. Then you'll hear from Jeremy McKinney, the first vice president, Kelly Stump, our treasurer, and Jeff Joseph, our secretary. So thank you all for being part of this panel with all of us. So again, quick overview on my end about sort of the political landscape. You're going to hear a lot about a lot of challenges and opportunities, the details from other folks in this panel, and I'm just want to talk about the sort of generalized environment where some of this this is happening. So although many of us are frustrated by the pace of change, not quite fast enough for many of us in terms of undoing some of these policies, and yet at the same time, it's just really a confusing and frustrating time. It seems like there has been a lot of change coming at us and a lot of adjustments. So first and foremost, let me just take a second to say that AILA is committed to continuing to do what we've been doing for the last 4 years, is making sure we get in front of you as information as fast as we possibly can, but more importantly, as thorough as we possibly can to get you an explanation of what these changes mean, what it can mean to your practice, what ways to explain it to your clients. So again, if you don't get the daily AILA 8, you contact membership at AILA.org and get yourself signed up for that. That has a daily reporting of most of these big changes that are happening in immigration law. If you haven't seen the client flyers that we've been creating in order to help you explain all of these changes to your clients, please search for those client flyers on AILA.org. They're really, really valuable. We've got a lot of locations, dedicated spaces on the AILA webpage for regular updates. These issue pages are covering the hot topics of the many of which are discussed here on an ongoing basis. So find those web pages on the AILA website, and that's a great source of keeping you up to date on all the changes that you're likely to be hearing about. And the other thing is we're going to continue not only keep our foot on the gas as it relates to resources, but also as it relates to advocacy and litigation, so that we can increase the pace of the change that is happening in the new administration. So in terms of those changes, most of the attention is going to be fixed on the administration, because Congress is in a position that I have never seen them in many of my years of witnessing their dysfunction. It's just a lot of uncertainty about what could possibly get done legislatively. Donald Trump continues to hold sway over the Republican Party, and I think that has caused a lot of confusion within the party about what their agenda could or should be, and it's created a lot of fear about getting primaried or getting attacked by the president if they take positions that he doesn't agree with. And as we all know, immigration is an issue that he has largely been opposed to. So the ability to get Congress aligned around immigration issues is not something we should give up on, but we should go into it knowing that it's going to be a real battle. So it's going to begin at the grassroots level. Start talking to your members of Congress at their local offices. Bring clients, bring influential members in your community to engage in conversations with them so they can understand what's possible and why. So in terms of the focus on the administration, if you didn't see the keynote session exchange between myself and Ali Mayorkas, I encourage you to find it and listen to it. I think it is evidence of two things. Number one, I have to give the administration, or at least Ali Mayorkas, credit for the fact that he was there and he was willing to answer tough questions, and he is clearly personally committed to the work that he's doing. He acknowledges, and I think he is struggling with a behemoth of a ship that he is trying to turn around, and I think they are honestly committed to deep and lasting change, which means that it's not going to be as fast as many of us would want. That being said, we have to continue to hold them accountable for the things that they can and should be doing now. So I think the respectful dialogue that I think he and I tried to engage in on that is evidence of what we can and should be doing with the administration. You got to speak truth to power, but you got to do it respectfully, and you got to listen and be partners with them in being agents of change. So I think that that's going to continue to happen with the Biden administration. There has been some real successes, as I discussed with Ali. There's also been, with Secretary Mayorkas, there's also been some very disturbing examples of a lack of resolve, a lack of confidence or commitment. I thought the flip-flop on the refugee numbers were one of the most telling examples of just trying to find their footing in this political landscape. So we got to keep pushing and encouraging them to do the right thing. And there's also, I think probably Jennifer or others will mention, there's also some indications that their perspective on employment-based immigration, particularly on high-skilled immigration, is not where we want it to be. The H-1B lottery rule not being rolled back, some of their language and policies that they've adopted that people will go through, I think is evidence that there is a lot of work to be done with this administration when it comes to those issues. So we're going to do that work, and we will always have litigation in our back pocket, as we have used over the last 4 years to push for the change that we think is necessary. The good news in all of this is the relationship between AILA and the agency and the administration and members of Congress is as strong as it has ever been. Building this back has involved a lot of dialogue with a lot of really truly committed people in the agency, and that's good for us, but it's also good for the change that we want to see. So we're going to continue to lean into those liaison relationships. Kudos to the liaison committees and the new committees that are going to be stood up in the new year ahead. There's a lot of work to do, but they've clearly been doing it, and they've been doing it well. So I'm going to end on that very positive note of a dialogue being open for us to be a catalyst for change. And I'm going to turn it over to Jennifer Meir to start talking about some of the things that we want to prioritize in that effort.
Thanks, Ben. So I am tasked with discussing USCIS and the Department of Labor and the things that are hot topicy within those two agencies. I don't think you can get any more hot topicy than the news that just broke a few minutes ago, right before this call started. USCIS announced some very welcome flexibilities for people who are submitting benefits requests to a USCIS lockbox. They apply only to benefits requests submitted to a lockbox, not to service centers or field offices. And they're only effective for 60 days from June 10th until August 9th. If you submitted a benefit request to a USCIS lockbox between October 1st, 2020 and April 1st, 2021, and that request was rejected during that time frame solely because of a filing fee payment that had expired while the benefit request was being receipted in and you were waiting to get your receipt notice, you may resubmit that request with a new fee payment. If USCIS agrees that it rejected the benefit request because of the delay in issuing the receipt notice and processing the check, then USCIS will deem the request to have been received on the initial filing date it was first received, and they will waive the $30 dishonored check fee. That's good news. It's a nice recognition of USCIS trying to accommodate its own processing delays and to accommodate people who are going through the system. USCIS will also allow applicants and petitioners to submit documentation with a benefit request resubmission, demonstrating that because of that time that elapsed between when the benefit request was originally submitted and when USCIS rejected it, an applicant, a co-applicant, or a beneficiary or derivative has reached an age that makes them no longer eligible to file for the benefit requested. They aged out because they were waiting for USCIS to take action. If USCIS agrees that the delayed rejection caused that person to become ineligible due to their age, then CIS again will accept the request, deem it to have been received on the original filing date. They stress that that flexibility does not apply to Form N600K, but it will apply to other forms that are submitted through the lockbox. So those are some welcome accommodations that the USCIS is making in response to, a recognition of its own processing backlogs and inability to effectively intake all of the thousands and thousands of filings that were submitted during that filing window between October and April. Just yesterday, CIS also announced that it is increasing the validity period for adjustment of status-based EADs from 1 year to 2 years for both initial filings and renewals, which is great because hopefully that will save the majority of adjustment of status applicants from having to file extensions of their EADs if their adjustments can be completely adjudicated within the 2-year validity period of the initial EAD. It's going to save everybody a lot of time and resources. They also revoked the July 2018 policy memo that permitted officers to deny benefits applications without first issuing an RFE or a notice of intent to deny. And they reinstated the June 2013 memo that instead instructs officers to issue an RFE or a notice of intent to deny where submission of that additional evidence might result in approval of the application. So again, a welcome recognition of the sort of faulty judgment of prior Trump administration policies and reinstating policies that make more sense and will result in fairer outcomes. They've also updated and expanded their criteria for seeking expedited processing of applications, including further explaining and expanding upon what would constitute a severe financial loss to a company or individual that would enable someone to qualify for an expedite. Also welcome news. So it's great to see the administration taking these actions to try to do what it can to improve efficiency and fairness in the system. You can't talk about USCIS without discussing processing delays. We are all frustrated with the insane processing delays at USCIS across all case types. Overall, processing times have surged by 101% from fiscal year 2014 to the end of fiscal year 2019. And while the agency has not significantly reduced its backlog, there are some positive signs. In addition to the things I just mentioned that they've done within the past 2 days, they've also already adopted some measures to improve efficiency, like reusing biometrics, restoring the deference policy. They are waiving many employment-based adjustment of status interviews. And of course, the administration has revoked the public charge rule, which is a huge step forward in the direction of efficiency and productivity. In April, USCIS also actively sought comments and input from the public about how to reduce barriers to obtaining legal immigration benefits. AILA submitted a comprehensive response to that request on May 19th, which is posted on the AILA website. We've also published a policy brief titled How USCIS Can Dismantle the Invisible Wall Slowing Case Adjudication. And we will continue to welcome opportunities to engage with CIS constructively on how to improve efficiency and reduce processing times that are causing so much hardship across all areas of legal immigration. I think it's an amazing sign that the Secretary of Homeland Security, a former director of USCIS, joined us today, and his candor was very much appreciated during that conversation. As Ben said, I think that the administration is really trying to get things right here. It's going to take a while, and I know it's hard to be patient when we feel like we've been waiting forever for some kind of semblance of justice and efficiency, but we need to wait a little bit longer. Also remember that CIS still does not have a confirmed director. Orja Du had a confirmation hearing on May 26th, but the Senate has not yet voted to confirm her as the next USCIS director. Once there is a political appointee at the helm of the agency, I think we can expect a lot more action, a lot more quickly. The fact that they've done so much without her yet being appointed is a very good sign that more will come once she is appointed. And during her confirmation hearing, reducing the processing backlogs was one of the key priorities that she indicated she would tackle if she were confirmed. And those of us who have known and worked with or in the past believe her to be a person of good faith and commitment to improving fairness and productivity and efficiency within the agency. Of course, the other elephant in the room with regard to USCIS is customer service. We can't talk about CIS without talking about the almost abysmal lack of customer service right now. That was a bug by design of the prior administration, and they've done everything they can to try to dismantle and disrupt USCIS customer service. Again, those things aren't great yet under the new administration, but we have seen a positive commitment to improvements and a willingness to engage with stakeholders that really was wholly absent for the past 4 years. So we need to give them credit for that, and we need to give them time to make changes. In the meantime, the Ombudsman's Office had a recent stakeholder engagement on USCIS customer service that included things like how to reach tech support, scheduling biometrics, making expedite requests, and the follow-up Q&A on that was posted to AILA.org on June 2nd. You will also find other practice pointers on the website about how to navigate the customer contact center, how to maximize your chances of speaking to an actual human being about your case. So we're trying to do what we can to get you the resources that you need to navigate the really broken system that we have right now until USCIS can get it fixed. We are very grateful to have a number of key personnel from CIS joining us for the USCIS Open Forum, which will take place today at 1 p.m. Eastern. So we urge you to attend that session where many of these pressing issues are going to be addressed, and CIS staff will be there to talk about them. With regard to the Department of Labor, the AILA Department of Labor Committee has been hard at work. Last week, AILA submitted comments on 3 different regulatory requests from the Department of Labor. They commented on a DOL request for information concerning data sources and methods for determining prevailing wage levels, and they provided recommendations on how the DOL can ensure that prevailing wage levels reflect actual real-world wages. Also, last week, AILA submitted comments on the ONET data collection program and provided recommendations on how the DOL can ensure it produces accurate and current information while also expanding the number of stakeholders to respond to those ONET questionnaires, which is part of how you get accurate and current information, is you get more people to participate in your surveys. AILA submitted comments and provided recommendations on the proposed revision to the PERM form, the ETA form 9089, application for permanent employment certification. For the past few years, all throughout the Trump administration and before, AILA has maintained and strengthened its liaison relationship with the Department of Labor. And we are very pleased that representatives from the DOL will be joining our DOL Open Forum tomorrow at 2:30 p.m. Eastern. Please be sure to listen in as the Department of Labor officials discuss various topics, including the transition to the 2018 SOC codes that will now, as of yesterday, apparently take effect on July 1st, 2022, instead of July 1st, 2021. So that's a new development that you can hear more about during the open forum. Also, the new form ETA 9141 prevailing wage request form, and they will also field questions relating to the LCA and PERM processing. So now I'm going to turn it over to Alan to talk about employment compliance and verification issues and the USCIS field offices.
Thank you. Welcome to the Wild West, and we will sort of talk about the field ops first. And I think that what's unique about field op and what's great is that we have the network attorneys that can help you from the chapter level understand what's going on at a specific field office of someone who goes remotely. Since most of us have national practices, some practices at one field office may not mirror another field office because of whatever those local procedures may be. And as we found over the last year, some days they're open and some days they're closed. Some days you get notice and some days you don't. And that's really frustrating for clients overall. In addition, appointments that generally you could attend, now you have to sort of phone in telephonically, which is a whole nother level of sort of jumping through hoops to sort of help your client. And so what AILA did and has done is put together a practice pointer back in March that sort of talked about these in-person sort of local office meetings. One of the things that has recently changed that is the benefit that most people are calling offices to sort of talk about when are my fingerprints going to happen, or I need to reschedule them, is that the fingerprint, the actual ASC offices are open longer now. So people might have appointments past 5 o'clock or early at 6 o'clock in the morning in some places. I think in some places it's 7 to 7. So you just sort of watch that. And when your client says this happened, just say this is great, because they're trying to capture more people to push more benefits along, because that's one of the backlogs sometimes in sort of issuing the underlying document is they haven't done the background screening because they don't have a current fingerprint. Logically, your fingerprint doesn't change, so I don't know why they need a new one. We saw over the last year that there was some move in sort of saying that they were skipping some fingerprint appointments for people whose impressions they already had, and they could reuse for whatever reason, and that continues to happen. I've also had reports at the national level that some offices, a benefit may be scheduled to be received at an interview at a local office, and the local office will approve the case a week before the actual interview happens in order to keep down the number of cases that are coming in for clearly approvable cases. I think approvable cases probably should sort of have the same benefit. I've also had an increasing sort of decline in the amount of employment cases that I have had rescheduled. I mean, interviews that are scheduled at local offices, although the overall processing is fairly slow. The scheduling of those interviews, some of them I've just had approved from the local benefit office. So I think that that's a good move and we should watch that. I think as Jennifer sort of stated earlier, one of the things that AILA did at the beginning of this year is sort of write a platform for UCIS to do better customer service and better processing. And the very first thing they did, that whole thing about the return the $30 fee, that was our suggestion to them. So they're listening to us, has been sort of highlighted in the keynote session about what we think would help better impact them and their caseload as they sort of walk alone. And I think in that union, going to AILA.org and exploring the chapter function to see who the liaisons to tell you what's happening in those specific regions can benefit you dearly. That also includes some of these odd naturalization appointments that are sort of popping up. So I think when someone receives a notice, as I do in my office, and it's sort of weird, I go, yep, that's what it is, right? You know, because when you get the copy, you're informed just like they are when someone had a late ASO appointment, and also with the delays. Now, this is where there's really, I mean, you kind of need to have a full service person who's able to work that 1-800 number to get the customer service if you have a problem that the scheduling of a local office appointment. So what I've recently told my clients is, unless it is absolutely impossible, we're not rescheduling anything anymore. You're just going to go to your fingerprint notice, whatever it is, you're just going to go, because that's a very difficult process to go through the rescheduling to know when you'll get back into the system, understanding the backlog. Of course, it's the client's choice, but let them know that there are a lot of steps involved in getting that back on schedule to get them their cases back in the mix. The other thing that I've seen or had some reports of in my practice is the separation of some family members for appointments. Was odd that one day the son dependents will go one day and then The other case is still pending, although they were filed at the same time. Their receipt numbers are just 1 digit apart. And there's been a lot of sort of follow up on that, but I just tell my clients that that's sort of just the processing that goes through. Now that we're sort of done with the Wild Wild West, let me take you to the lowest level, I guess, or the highest level of hell, which is employment verification. And let me tell you why it's hell. Because there are various rules that are published that have not gone through any regulations. They're just saying you can do X, Y, and Z at this point in time. UCIS is not issuing receipt notices. Maybe you'll get the receipt notice, maybe you won't. Maybe you'll get it in time, maybe you won't. Maybe the case will be adjudicated in time, maybe it won't. And so, and in most of these offices, the HR person whose job is to sort of do this verification is working remotely. So they're not even with the regular documents that are sort of going on. So in most of my client offices and this is something that's super important to understand, that this is for all businesses. So this is a marketing opportunity for you to sort of talk to everybody. There are stacks of I-9s for different periods, meaning the stacks of I-9s we had before COVID, the stacks of I-9s that happened during COVID that people might have used sort of a remote way of verification for, and the stacks of I-9s that are coming in now, as well as the stacks of I-9 they have for their temporary workforce and sort of enforcement and compliance of making sure someone's status is sort of in. So that's one of the major problems, is managing those different levels and understanding that each month something new comes out with regards. And the most recent thing that has come out with regards to the verification is that the remote verification process will continue to August 31st. Then on August 31st, magically, you should then make sure and verify everybody you hired during the COVID period within a 3-day period. The people who did the initial screening should be the people who also do the verification at that time point. What a disaster. If you are a mom and pop shop, that may be possible, but if you're a multinational hiring institution, that is an absolute nightmare. So many people are starting to go through that process right now of doing the remote verification process that continues. In addition to that, there are a number of cases that were started under the Trump administration, sort of the audits for I-9s that are just now becoming due, and we're getting some determinations on those, as well as OSHA is also working with regards to complaints that are filed by foreign nationals with discrimination from different companies. And so we're sort of watching the forefront on that, and you can follow all of those things from the verification committee on the AILA.org site, where we sort of have updates. The last meeting they actually had was in last year, October of 2020, but there's still a lot of good facts there. And just today, UCIS issued another I-9 announcement with regards to H-2Bs and sort of their portability and how you can handle that on an I-9 form. So as an employer, you basically need to be an immigration attorney to complete the I-9 form. And that, I will turn it over to Farshad to talk about the Department of State and CBP, which I'm sure is much more organized.
Thank you, Alan. A lot to cover, folks. I'm going to fly through them and refer to many AILA document numbers, so have your pen and paper ready. Turning to CBP, CBP is moving away from adjudicating NIEs and requesting to contact DOS first. They affirmed that NIE will be only issued under exigent circumstances and that DOS has the jurisdiction. Members should follow the particular procedure listed on AILA for each port, but must go to post first before going to CBP. However, you do not need to go to the consulate for humanitarian and emergency situation, but it has to be real humanitarian, not business related. Regarding returning LPRs after prolonged stay due to pandemic and airlines refusing to board them, on March 5th, 2021, CBP issued a reminder of current policy on boarding a lawful permanent resident through their carrier liaison program. This guidance was published on AILA.org under document number 210400934. Accordingly, anyone with one of the listed documents must be allowed boarding, and they reminded the airlines that airlines should not be determining admissibility of travel outside the parameters of the document's requirements. Nonetheless, we have received many reports that airlines are not following this guidance. We are seeking case examples so that we can share this with CBP to attempt to cure this issue. Please share your experience with us under AILA document number 2104234. In memorandum dated June 1st, 2021, DHS Secretary Ali Mayorkas officially ended the Migration Protection Protocol, MPP, also known informally as Remain in Mexico. For details, you can refer to AILA document number 210-60141. Waiver process at the northern borders. CBP has confirmed that the waivers will be processed in the same manner they were prior to the COVID restrictions. CBP has resumed capturing biometrics. For the background, once an eSafe application is submitted, applicants and attorneys are notified electronically that they have 45 days to report to an eSafe designated port of entry for biometric collection. The 45-day deadline to submit biometrics are currently suspended, and as long as temporary travel restrictions are in place, eSafe applications will remain in suspended status. Once the temporary travel restrictions are removed, eSafe applications will return to the previous status and timeline requirements. For biometrics taken by Royal Canadian Mounted Police, CBP confirmed that if an applicant's returned civil product and accompanying records were dated and endorsed by the RCMP within 15 months of submission of the form I-192, CBP will accept and process the applications accordingly. As we all heard, there are rumors that the Canadian border restrictions will be lifted on June 22nd. CBP was not able to confirm this information. They will inform the traveling public in advance prior to the border reopening to non-essential travel via the local and regional media outlets. Until then, we have to be patient with the rest of the US-Canadian border crossers. Regarding UCMCA, formerly NAFTA, L1 adjudications for Canadian nationals, the CBP Liaison Committee, based on recent reports from a member of Differing Information, has confirmed with the CBP headquarters that northern borders continue to have the authority to adjudicate intermittent and commuter L1s, both initial and periods of admission. If you have a different experience, please make sure to submit that information to reports@aila.org so our CBP Liaison Committee can alert CBP headquarters. Also, we urge you to review the practice alert we published in May 2019. It is AILA document number 190-30730. It's a useful resource to review. In the last 2 days, CBP issued 2 carrier liaison program announcements. The first one was for family reunification FOIL. This is regarding the May 7, 2021 interim guidance for the parole of certain separated parents, children, and other family members into the US for reunification. Details regarding these announcements can be found at AILA document number 210-60932. The second announcement was detailed clarification for exemptions for the COVID-19 health proclamation. This document also can be found under AILA document number 210-60938. State had already listed these on their website, but the consistency of the information announced by both agencies is a positive note. For more information on CBP and the latest updates, please make sure to attend our CBP Open Forum. That will take place this afternoon at 4:15 p.m. Eastern Time. Now let's turn to the state. We had our liaison meeting with this Department of State Visa Office on May 27, 2021. We have posted the liaison notes on aila.org. Is AILA document number 210-52740. As we speak, our Department of State liaison and AILA national team worked hard to release our meeting takeaway notes, and they are now released. You can find them under AILA document number 210-61098. Overall, things don't look pretty regarding consular reopenings. Immigrant visa process has been resumed in recent months, but still not nearly close to their normal processing capacity. We have over 500,000 pending immigrant visa cases worldwide. Reports indicate 76% of the US consulates are closed or opening in mission critical emergency status. Consulates are making NIV appointments, then canceling them 2 to 3 weeks prior to the appointment. This is creating a lot of anxiety for our members and their clients. The staffing is low, and this is apart from pandemic. There are over 100 fewer consular officers than when President Trump assumed the office. agency is also suffering financially, mostly because the agency is fee-based and they have been collecting only a fraction fees they would have in a normal year. Most of the consular officers' manpower is exhausted on NIE waivers, and as we know, NIEs are free of charge. There are also local COVID restrictions in respective countries that make ability to fully staff posts very difficult. So COVID is not the only problem, and situation will remain fluid for some time. Regarding the NIEs and COVID-19 health-related presidential proclamations, we all thought that the bans would get easier under the Biden administration, but that's not true. Members need to be prepared to continue for continued fluidity. NIE criteria became more restrictive. State removed the executive and significant economic impact only to bring them back again as criteria. President Biden also added South Africa and India to the banned countries. Until recently, there was only NIE criteria in Europe, but after May 27, 2021, we also have NIEs for all countries subject to the presidential proclamations. NIEs tend to be adjudicated more strictly at the consular post. In addition to critical infrastructure, etc., you must prove that the job cannot be performed remotely or by proxy. In the published guidance by the state and CBP, we think that there is a gap regarding OPT holders coming back from a trip abroad to resume employment, but we will try to sort this thing out at our open forum with the state and CBP. Bottom line is that eradicating COVID is a high priority for President Biden administration, and we need to continue to watch the trend. Regarding the visa bulletin, based on the implications of COVID-19 and processing limitations, fiscal year 2021 family-based and employment-based annual limits will not be reached. Unused family numbers are added to the employment-based allocation the following year and vice versa. Due to the immigrant visa ban covering several months of this fiscal year, combined with the reduced state of consular processing and an immigrant visa imperative that is focused on immediate relative cases rather than preference categories, numbers not reaching the annual limit is not surprising. According to Charlie Oppenheim, fiscal year 2022 family-based limit will be 226,000 under the INA annual limit. It has been like this since fiscal year 2000. Employment base is 290,000, at least for fiscal year 2022. This is an all-time high limit. Prior to this year, the highest employment-based allocation ever was 158,000. This year allocation is 262,000. China and India employment-based second preference dates will be advanced, as well as other categories except EB5 China. Dates will be moved aggressively throughout the end of summer and most likely through early part of fiscal year 2022. Many of the family-based priority dates will also advance through the summer. There is no anticipation of final action date retrogression in both employment-based and family-based throughout fiscal year 2021 and for foreseeable future in 2022. All diversity visa categories will remain current in fiscal year 2021. Unfortunately, as of now, there is no meaningful procedure in place to allow DV 2021 winners to prioritize their appointments. We have discussed this with the visa office and they only refer to immigrant visa prioritization announced on April 30th, which places DVs in the 4th tier. At this moment, there are several litigations on this issue. Jeff is gonna cover some of those. The big question is that will we have another EB surge in October? It all depends largely on USCIS's ability to approximate the 262,000 allocations by the end of September. Also, everyone needs to watch whether EB3, EB2 India will flip. So far, Charlie has no visibility on those filings. US Consulate in Mexico announced that they will not process any third country national applicants. That is on their website. And lastly, Secretary Blinken, in his opening remarks before the Senate Committee on Appropriation, requested a direct appropriation of $320 million for consular services worldwide so that they can continue to provide vital services to Americans and those who seek to study, to travel, and to do business with the United States. Hopefully this will be granted, so it will bring back some order to the state's business. Please make sure to tune into our state open forum tomorrow, Friday morning at 9:30 a.m. Eastern Time for more in-depth and detailed information. Now I'll turn to Jeremy McKinney, our first Vice President, and Kelly Stump, our Treasurer, to get the latest on Scouts, EOR detention, and enforcement issues. Jeremy, Kelly.
Thanks, Farshad. Turning to this year's Supreme Court and EOR update, I'd like to start with an observation. After the election, we quickly saw the removal of key legal challenges to the Trump administration shenanigans from the Supreme Court's docket. Challenge to MPP, gone. Built that wall, gone. Instead, this year's Supreme Court term could be characterized as time spent resolving long-standing legal disputes. This year's term has also been a reaffirmation of Justice Gorsuch's pivotal role in the resolution of those disputes. So let's dive in. In Pareto versus Barr, a non-citizen pled no contest to a criminal attempt charge arising from his use of a fraudulent Social Security card to obtain employment. In removal proceedings, Pareto pursued cancellation of removal. However, DHS maintained Pareto was ineligible for cancellation because the crime was a CIMT. Now, this Nebraska statute was divisible with subsections, some of which were CIMTs, some of which were not. However, the conviction records did not point to which subsection Pareto was convicted of violating. Justice Gorsuch, writing for a 5-3 majority, stated, the INA expressly requires individuals seeking relief from lawful removal orders to prove all aspects of their eligibility. That includes proving that they do not stand convicted of a disqualifying criminal offense. As the Fourth Circuit stated a decade ago on the same legal question, fidelity to the INA requires that the non-citizen, as the party bearing the burden of proof, suffer the detriment. So the bottom line here, coordination with criminal defense counsel continues to be key to ensure that the conviction record is either free of ambiguity or ambiguous, depending on the circumstances. If discretionary relief is on the line, you want the record to clearly state whether the offense falls within the removal ground or does not. Conversely, if DHS carries the burden of proof, I would argue ambiguity is your friend. Next up was another Justice Gorsuch opinion, and it's a big one. Nice-Chavez versus Barr, a 6-3 follow-up to 2018's Pereira decision. The bottom line, again, the stop time rule contained in the cancellation or removal statute stops the clock upon service of a notice to appear. But the statute defines a notice to appear as a document which contains in part the time and the place of the hearing. You know, a notice telling someone when to appear. A notice that does not provide notice is insufficient to trigger the stop time rule. Thus, the dissenters in the divided BIA opinion matter of Mendoza-Hernandez have won the day. Earlier today, ICE released guidance online for non-opposition of motions to reopen filed to pursue a cancellation application previously denied or not pursued due to the incorrect application of the stop time rule. For efficiencies, members are encouraged to file motions to reopen directly with the immigration court instead of requesting joint motions with DHS. The question is how Nice-Chavez will apply in other contexts. For example, post-conclusion voluntary departure requires physical presence in the US for a period of at least 1 year immediately preceding the date the NTA was served under Section 1229A. Same language. Use Nice-Chavez. What about the removal proceedings themselves? Were they properly initiated with the filing of an NTA missing a hearing time or date? Thus far, we are seeing a mixed reaction among immigration judges. A well-circulated decision from one immigration judge post Nice-Chavez makes clear that an NTA missing a time and date could constitute a procedural claim processing rule violation. Now, this is a rules violation without the jurisdictional implications. What it means is that in our motions, in addition to claiming a lack of jurisdiction, an argument that should be raised, but which seems to lose almost every time, one might also claim at the earliest possible moment of removal proceedings or in a motion to rescind an in absentia order that the proceedings were never properly initiated. This claim processing violation is winning the day in some courtrooms, but we will have to see how our circuit courts address it in the months and years to come. Next up is U.S. versus Palomar Santiago, a unanimous decision delivered by Justice Sotomayor. The decision is the first of 3 rejections of Ninth Circuit law. The quote, illegal reentry after deportation, unquote, statute contains a 3-part test for attacking the validity of an underlying deportation order. The Ninth Circuit had excused 2 of the 3 parts of the test where the substantive grounds of the removal order no longer existed. In this case, it was drunk driving as a crime of violence. The unanimous court said defendants would still need to satisfy all 3 parts: exhaustion of administrative remedies and the deprivation of the opportunity for judicial review. On June 1st, another unanimous decision was issued, and this is another one written by Justice Gorsuch. Here, it was a Ninth Circuit rule that a reviewing court must treat testimony as credible and true, absent an explicit adverse credibility determination. Justice Gorsuch rejected the Ninth Circuit case law with crystal clear language. He said, and I quote, "Immigration cases like these should proceed as follows. First, the fact finder makes findings of fact, including credibility determinations. The BIA then reviews those findings, applying a presumption of credibility if the IJ did not make an explicit adverse credibility determination. Finally, the Court of Appeals must accept the agency's findings of facts as conclusive unless any reasonable adjudicator will be compelled to conclude otherwise." Not the result we wanted in the advocacy community, but we got a clear, concise rule, and most importantly, a recognition that there remains a presumption of credibility at the board level. Earlier this week came the 3rd unanimous rejection of Ninth Circuit case law, and it was a heartbreaker. In Sanchez versus Garland, the Supreme Court concluded a grant of TPS does not constitute an inspection and admission or parole for purposes of adjustment of status to residency. There was a long-standing circuit court split on this issue, and the court unfortunately resolved it. 2 things give this decision a particular sting. First, the Biden administration's DOJ did not have to adopt this view of TPS and adjustment and argue it before the Supreme Court, but it did. And that's a disappointing departure from President Biden's prior support of the TPS community. Second, the language Justice Kagan employed to justify the court's point of view went beyond the legal language at hand and incorporated irrelevant observations about parole, and then tied 245K into the description of the adjustment process twice in a very short opinion, as if that limited subsection that's only applicable in employment cases was a core component of the adjustment process. It was unnecessary. It was confusing dicta, contrary to existing agency law, when really you just had a very narrow legal issue for the court to decide. I'm concerned and will lead EOR and USCIS to change existing agency policy and law and begin to deny other applications for adjustment from certain non-citizens such as T or U non-immigrants who meet the eligibility requirements to adjust status. Thus, it is crucial, it is critical that our members push the agencies to adhere to existing precedent and policy and argue that this dicta does not alter the plain statutory criteria for adjustment outside of this context of TPS. This morning, in Borden versus United States, Justice Gorsuch joined Justices Kagan, Sotomayor, and Breyer, and concluded a criminal offense with a mens rea of recklessness does not qualify as a violent felony. While not an immigration decision, these ACCA cases often translate into courts' interpretations of the aggravated felony crime of violence. This plurality opinion is the judgment of the court, as Justice Thomas concurred in the judgment, forming a majority. Now, quickly turning to the BIA, there have been 25 BIA decisions, 4 AG decisions, and 1 EOR director decision since AILA's last annual conference. Almost all were against the person facing removal. There's a lot of damage that needs to be undone, and so far we haven't seen 1 AG decision yet from Attorney General Garland. This is not entirely surprising. President Obama's first Attorney General, Eric Holder, was confirmed a month earlier than Merrick Garland. However, AG Holder had managed to vacate his predecessor's decision in matter of Compion by June 3rd, 2009. But he didn't vacate Silva Trevino until 2015. So it's a mixed bag. We will see, but it is my hope that AG Garland acts sooner rather than later to repair the damage, especially to our asylum system in the areas of PSGs, such as matter of AB, matter of LEA, and the duress exception to the material support bar. Help is also needed in the area of crimmigration, where the AG and a collection of DOJ employees called the Board of Immigration Appeals continue to stretch their collective legal imagination to find removability. Finding aggravated unlicensed driving in New York a crime involving moral turpitude. Or matter of Nemus, where the board subdivided a categorically overbroad criminal statute not once, but twice, using the modified categorical approach to find a CIMT conviction. In other words, the board dissected the criminal statute until they found deportability. Similarly, in matter of Reyes, former AG Barr came up with an entirely new version of categorical analysis to find an aggravated felony where the criminal statute in and of itself is not a one-to-one categorical match to a specific aggravated felony. And that's matter of Reyes. The Barr's decision upends the analysis, and we will need to see how the circuit courts address it. On the administrative side of EOR, it seems like every administration, regardless of political party, makes the case for an independent Article I immigration court. Recently, EOR announced the return of a southern border rocket docket, an approach utilized by the last 2 administrations. It does not work. As Ben pointed out with Secretary Mayorkas, access to legal representation is already a challenge at the southern border. Asylum seekers must also reasonably corroborate their testimony, something that often takes time and resources. Third, we just sustained a 4-year frontal attack on asylum case law. Those horrible AG decisions remain the law of the land. Thus, a rocket docket for most asylum seekers will simply be an expedited denial. See how DOJ places its thumbs on the scales of justice, regardless of party. I will say it every year until it is our reality. It is time for an immigration court system. It is time for the immigration court system and the Department of Justice to divorce. All right, that was a lot. Now Kelly's going to talk about current EOR and ICE policy.
Thank you, Jeremy. Just to touch back on those asylum issues with the newly, I think it's titled the dedicated docket. It's going to be interesting to see because while DHS has suspended MPP, Title 42 is still in full effect. So, this is further complicating individuals' ability to seek asylum at the border. Jennifer touched on it earlier, but briefly, Title 42 is actually an ancient health law that the Trump administration creatively invoked in March 2020, disguising what is essentially a new travel ban, citing COVID preventions. It prevents individuals from entering the southern border subject to a few exceptions and exemptions. Individuals with visas can get around this problem by entering via air, but this is still incredibly problematic to our asylum seekers. It has led to the mass expulsion of thousands of asylum seekers, including those in desperate straits. I had the benefit of talking to Taylor Levy yesterday. She is actually boots on the ground down in Texas and California, and her practice is dedicated to these cases. She stated that the process is quite confusing and that individuals need to work directly with NGOs. She's offered up herself to help facilitate that process should anyone listening today need assistance, but the process is still confusing on how to obtain these exemptions and then enter the United States. When they do enter the United States, it sounds like these individuals are going to be a part of the dedicated docket that Jeremy was talking about. This is going to be implemented in 10 cities: Denver, Detroit, El Paso, Los Angeles, Miami, Newark, New York City, San Diego, San Francisco, and Seattle. Under the dedicated docket, the IJs are supposed to issue a decision within 300 days of the initial master calendar hearing, subject to the unique circumstances of each case, including allowing time for families to seek representation where needed. There are over 1.3 million individuals currently in removal proceedings, which is over 350 immigration judges. Dockets are backlogged for years already. Fortunately, ICE last week released a new prosecutorial discretion memo that I'm hopeful we will help work with ICE and can reduce this backlog by dismissing cases. So quickly, because we are running out of time. Under the memo, ICE announced 3 ERO priorities: national security, border security, and public safety. In discussing prosecutorial discretion, the memo discusses weighing mitigating factors against aggravating factors. Mitigating factors include length of residence in the US, military service, family and community ties, circumstances of arrival and manner of entry, immigration history, current immigration status, work history, pursuit of completion of US education, whether the person is a victim, witness, or plaintiff in a civil or criminal proceeding, possible immigration relief, contributions to the community, and compelling humanitarian factors. Aggravating factors include criminal history, participation in persecution or other human rights violations, prior immigration violations, and fraud and material misrepresentation. Where a criminal history exists, OPLA should consider the seriousness and recency of the offense, the sentence, and age of the non-citizen at the time the offense was committed. Interestingly enough, in this PD memo, OPLA can also cancel an NTA, continue proceedings, forego appeal, join in motions for relief and motions to reopen, and enter stipulations for relief or in bond proceedings. The memo outlines several categories for individuals eligible for dismissal of proceedings, including military members and immediate relatives of military members, individuals likely to be granted relief, compelling humanitarian factors, significant law enforcement or other governmental interests, and long-term LPRs. The memo also mentions that OPLA will have a monitored email inbox dedicated to inquiries and requests for PD. So this is something that is extremely promising in my view. I feel like the last 4 years we've been cut off with communication. Further, I find it interesting that the memo discusses the agency's previous ability to jointly move for admin closure, and it discusses the current conflict in the courts of appeals regarding Castro Tomb. So where administrative closure is not available, OPLA retains authority to decide whether to agree to a continuance for good cause shown. Hopefully we can somehow get administrative closure back for those cases that ICE doesn't want to dismiss outright, but where we don't want to have to perpetually seek continuances in court. I know that was like super fast, but we've got to get to Jeff, because what Jeff and his team have been doing with the litigation efforts is far more interesting than what I have to talk about.
Thanks, Kelly. And I promise you I'll be quick. When I ran for secretary last year, it was because I really believe that litigation needs to be an important component of AILA's portfolio. And with the leadership of Jesse Bless as director of litigation, we have really accomplished really prolific things against this administration to quash what otherwise was really just executive fiat, right? And it was just lawmaking by executive fiat. And so I want to commend to your attention a couple of panels on litigation that are going to be at the conference. We have a back-to-back session tomorrow on intro to immigration or intro to federal litigation and how to avoid motions to dismiss. There's also a removal litigation panel on expert witnesses. And finally, there's a business litigation panel as well on Friday. So make sure you attend those sessions. And I also want to thank Ron Klasko and Eleanor Pelta for the amazing work that they've done on the Administrative Litigation Task Force in monitoring and identifying issues which AILA should be litigating and bringing those to the forefront. They've just done a really incredible work as chairing that committee. All right, so let's delve into the cases that AILA is litigating. The first one that I want to talk about is the Gomez case, which is the DV 2020 challenge. It actually started out as a much broader challenge to the immigrant visa ban. It was assigned to Judge Mehta, and what ended up happening in that case is Judge Mehta determined that really the real problem, the real crisis had to do with diversity visas. And so what ended up culminating in that case is that Judge Mehta entered a really extraordinary order that preserved 9,095 diversity visas beyond September 30th. In other words, the government argued that September 30th is the deadline, and if you don't file your application and get your green card by that date, you're out of luck. Mehta knew that that was simply not possible, especially with the snail's pace that DOS was operating under, and so he reserved 9,000 visas. So really extraordinary decision from Judge Mehta. The next case I want to talk about is the Kinsley case. This is the challenge and by the way, the Gomez case was filed by AILA in conjunction with the Justice Action Center and Innovation Law Lab. It was consolidated with other cases, including a case filed by Impact Litigation, our group, as well as Curtis Morrison's team and Wasden and Benayas. Kinsley v. Blinken is AILA's challenge to the regional bans, the bans on people who have to quarantine before they come into the country. This case was filed by AILA along with partners at Impact Litigation. We intend on filing the motion for summary judgment on Friday with an expedited briefing schedule, hoping to have that case fully resolved by July. So watch out for that. The good news on that case is it's been assigned to Judge Boasberg, who is the judge that was already assigned to the Milligan case, the K1 Milligan case, and has already ruled that 212F does not give the executive authority to shut down visa processing. So we kind of know how this case is going to go. The next case is Edekuni v. Mayorkas. This is a challenge to H4 and L2 delays in issuing of work authorization. The complaint was filed on this one in March with a preliminary injunction filed April 15th. The preliminary injunction is pending a decision, but essentially what has happened is that the agency has agreed to waive the biometric requirement for H4s and L2s. So we've gotten a partial settlement. It still doesn't resolve the enormous delays on 539s and the failure to adjudicate those at the same time, but it's at least a partial victory in that case. Next case is Humane Society of New York versus Mayorkas. As you might know, the Department of Labor and USCIS has proposed an H-1B wage-based lottery rule, which would change the methodology for determining who gets a lottery number. And lottery numbers would go to the highest paid wages rather than lesser wages, which sounds good in theory, but it would shut nonprofits, rural hospitals, and others out of participation altogether in the visa system, in the H-1B system. Additionally, it was implemented by Chad Wolf, who, as many courts have held, never had authority to publish illegal rules in the first place. So we're very confident about the outcome of this case and anticipate that we'll be moving to summary judgment on that case very soon as well. And then also Mad Kudu is another case we filed, again, pro bono counsel there was a number of people involved in this, but it was started by the AIC with help from AILA and Impact Litigation, as well as the law firm of Vanderhouten Borgagliano in San Francisco. And this one challenges the H-1B specialty occupation decisions as they relate to market research analysts. The summary judgment motion was filed March 15th, and we are currently in settlement talks to resolve this case without a judgment. So stay tuned for how this will implicate other specialty action cases. There's a couple of other cases that are sort of pending that I won't go into now, but the Purdue case is one of those that challenged the DOL wage rule that would have re-leveled the wages. Summary judgment was granted on that case, and the rule has been sort of indefinitely delayed until well into 2022. So I'll stop there with the understanding that you're going to hear a lot more about these cases in the various panels, and I know that you want to get into some of the meatier substantive stuff. So thank you so much for this, and I will turn it back over to Emmy to bring us home.
Thanks, Jeff, and thanks to our panelists. We ask that all attendees complete the evaluation at the end of this session. The session evaluation link is located on the virtual site under each session's description. Your feedback is very valuable for future conference planning. The CLE code for this session is 3999. Again, that code is 3999. Be sure to check out the exhibitors and our exhibit hall. And also thank you to our sponsor, LawPay. Thank you for attending this session. This concludes the Hot Topics strategy session with AILA National Officers.